All right. Welcome back. We're now going to begin with the second portion of our symposium today. My name is Dave Branham. I'm a 3L member of Journal of Legislation, and I'll be introducing this portion. So first thing we'll get to do is to hear from the President of the Uniform Law Commission, President Cassidy, and then we'll move right into a panel, and I'll introduce both President Cassidy and the panelists right now. So President Cassidy is the current president of the Uniform Law Commission and a practicing lawyer in Vermont. He has been a member of the Uniform Law Commission's executive committee for 8 years, serving as a member of the Uniform Law Commission drafting committees on the Model Punitive Damages Act, the revised Uniform Arbitration Act, and the Uniform Apportionment of Tort Responsibility Act, and he chaired the study and drafting committees on the Uniform Collateral Consequences of Conviction Act. Joining President Cassidy on the panel will be both Anita and Rick from earlier. Steve, I'm sorry about that. Anita and Steve will be joining us on the panel.
We can rename it.
And then also we will have Professor Fox on the panel as well. Professor Fox is a clinical professor here at Notre Dame Law School, where she runs the Economic Justice Clinic. Her advocacy and research focus on issues of predatory lending, primarily in the housing market. She is on the Consumer Financial Protection Bureau Consumer Advisory Board and the Advisory Board of the Indiana Foreclosure Legal Assistance Program, the Predatory Lending Committee of the Bridges Out of Poverty Initiative, and the National Association of Consumer Lawyers. And Professor Tidmarsh, also professor here at Notre Dame, will be moderating the panel. Professor Tidmarsh is the author or co-author of a number of books, including Case Books in Fields of Civil Procedure, Complex Litigation, as well. He's also written and participated in a number of law review articles in the fields of civil procedure and complex litigation and torts. So just procedurally, after President Cassidy's done, we'll move some chairs up, have a panel, and there'll be an opportunity for questions both about what President Cassidy has said and then whatever the panelists decide to talk about in regard to the uniform law approach generally at that time. So please join me in welcoming the new participants in our symposium.
Thank you, David. As David said, I'm Rich Cassidy. I'm the president of the Uniform Law Commission, and I've been doing this. That is, I've been a commissioner for 21 years, and my goal in making some remarks today is to give you, hopefully, a little put the process that resulted in the enactment by the Commission and hopefully the enactment by the states of the Human Trafficking Act in the broader context of what the Uniform Law Commission does, and then we can talk a little bit about how those things fit together. So what is the Uniform Law Commission? Who are these crazy people who spend their time and energy developing uniform laws? Well, it is really an organization of the states. That is to say, all of the 50 states, the District of Columbia, and the territories of Puerto Rico and the Virgin Islands are all members of the Uniform Law Commission. They provide the basic money, the funding that makes the Uniform Law Commission go, and they appoint people who are commissioners, people like Anita and Steve and I, through whatever process they choose. Most states choose to have their governors appoint Uniform Law Commissioners. Some states have a process that's a little different, where perhaps the President of the Senate appoints somebody, and the Speaker of the House appoints somebody, and the Chief Justice appoints somebody, and the Governor appoints somebody. But through one means or another, all of the states appoint Uniform Law Commissioners. There are approximately 350 Uniform Law Commissioners. They are all not only appointed by their governor, but they are either a lawyer, a judge, or a law professor. So they all come to this process with the expertise that comes from that background. And what we do is to meet together and confer on areas where it is thought that for one reason or another, state law should be the same or similar, identify those projects, those areas, and develop so-called uniform laws, promulgate really is the word we use, uniform laws, and then we go back to our states and we have a duty to seek the enactment of those laws in our state. We've been doing this since 1892, although I don't think there are any commissioners who survived that long, but we do have a commissioner who's been a commissioner for 60 years. And the people who do it seem to, for some reason or another, to be very committed to the process. If you believe in the law as important, and I certainly do, it's a tremendous opportunity for a lawyer to bring that professional expertise in a way that's beneficial to the public interest and serves to promote the rule of law and the effectiveness of the legal process. Over the years, we've promulgated more than 300 statutes. And there are literally thousands of state statutes that have been enacted based upon uniform laws. They're not typically adopted verbatim. In fact, some uniform acts, and you may see this in the Human Trafficking Act, if you look at it, have brackets, places for states to make their own choices about things. And there are inevitably matters of translation that need to occur. So you need to refer to the right court if you refer to a court and that sort of thing. So they're not typically adopted verbatim, although we did have an act that's been enacted in 46 states or something like that in the last few years, the Uniform Enforcement and Family Support Act, which Congress requires be adopted by the states verbatim. Even then, verbatim becomes difficult because you can't quite make that work, and there are even there some little changes. But there are thousands of these statutes, and in a typical active legislative year, we think about legislative years as sort of major years and minor years. Some states don't meet every year. There's not every state's legislature's in session every year. Many states have short sessions where they are primarily dealing with the budget and some things that have to be done every year, but they don't do a full session every year. So we sort of think of them as major years and minor years. In a minor year, we typically will see about 70 uniform laws enacted across the country. And in a major year, typically over 100. This year was just a little over average. 103 uniform acts were adopted by the various legislatures of the states. How do we do this? I think of the process in really three steps. First, we gather proposals, and anybody can make a proposal. You can make a proposal if you have a good idea for an area where you think state law should be the same or similar. We study those processes initially through what we call our Scope and Program Committee, and Anita has just finished 2 years as chair of the committee, and Steve's been on the committee and is on the committee again this year. And they study these proposals and make recommendations to our executive committee about whether we should go after a particular subject area and develop a statute. Sometimes a study committee is appointed to actually take a proposal that looks promising and develop that proposal somewhat further before a final decision is made. And then our executive committee, with the advice of Scope and Program, makes a decision to go forward. It's a pretty significant commitment. It costs, we figure, about $250,000 to draft one of these statutes. And that is that's not accounting for the fact that all of the commissioner time that's involved is free. It's all donated. No commissioner is paid for their services. They work as volunteers. They may be paid for their expenses, but their services are all provided for free. And the process comes out of a study process and goes into a drafting committee. And drafting committees usually, not always, but usually plan to meet for 2 years. A reporter is hired to function really as the writer or the scribe for the committee and develops often an issues memorandum to lay out the problems that have to be addressed by the statute, and then a draft of an act. And then the committee meets and begins to work through that issues memo, or when they get to it, to the actual draft. and tries to improve the draft, come up with an excellent draft to present to the floor of the commission at its annual meeting. We meet in the summer, in the dead of summer, typically in July when the weather is nicest in my home state of Vermont. But I walk away for 7 or 8 days because this work is important and I love doing it. We meet every day, all day, except Sunday during that week when we take the afternoon off and people go see where they are and know that they're not just in an air-conditioned hotel conference room someplace. And we function as a committee of the whole. So of the 350 commissioners who are members of the conference, typically something between 275 to 300 are present for almost all of the entire week and present on the floor. And the drafting committee is at the front of the room, and the drafting committee goes through the act line by line. That is, each section is read by a commissioner, and then any member of the conference who wants to has the opportunity to get up and make a comment, make a suggestion, make a motion to amend the provision, be critical of the provision. And when I walked in earlier, my colleague Steve Wilborn was talking about how surprising that process can be, because what happens is there's a meshing of specialized expertise and more general expertise that I think is really, really very useful. One of my colleagues from Vermont, a really fabulous lawyer, but a generalist in the greatest sense of the word, is famous for getting up and asking questions and having some reporter, sometimes an Ivy League reporter, look over the desk and say, well, Commissioner, if you just turn the page, you'll see that your question's been answered on the next page. That might happen to him 2 or 3 times. Doesn't bother him a bit. He's back up on his feet again. And sooner or later, he'll ask a question, and you'll see that reporter turn to the chair and say, well, we didn't think about that. And that's a really very interesting process, and I've seen some really wonderful changes and improvements get made as a result of it. So that process goes forward at the annual meeting. A transcript of the remarks that are made at the annual meeting is then prepared, a verbatim transcript, and provided to the drafting committee. The drafting committee meets again, usually a couple more times, and then comes back to the conference again to do it all over again the second time, the second reading of the act. And then, assuming that we've gotten to the point where the act is felt to be ready to go, and as I say, that doesn't always happen, we'll go forward for a vote by the states and approval by the conference. In the case of the committee that I chaired, the Collateral Consequences of Conviction Act, we needed remedial help. It took us 4 years to get to that stage. And then we came back a 5th year and sought to amend the act because there was a U.S. Supreme Court decision in the meantime that resulted in our having to change. So the process is a little bit fluid. But once that's done, the states then get to vote on whether or not to adopt the act. And invariably, when there's that much time and energy been put into the process, what you see happen really is that a consensus is developed, and the vote by the states is typically reflective of that consensus. Very few acts draw very many negative votes, maybe 10 or 11, but typically 2 or 3, and that then amounts to promulgation by the Uniform Law Commission. We also have another product. We don't use that product very much, but it's called a model act. And that's what we do in a situation, at least ideally, it's what we do in a situation in which we see an area to improve the law, but it doesn't really fit the basic criteria that we have that the law should be the same or similar in every state. And obviously, there are lots of laws that just don't need that kind of similarity. But we still will occasionally go to a project of that nature and develop a model act. We did recently a model Administrative Procedures Act. Some years ago, a project that I was involved in early on in my career was the Model Punitive Damages Act, which the U.S. Supreme Court should have paid more attention to than they did, but that's another subject. So we do occasionally do that. But uniform acts, commissioners are expected to take back to their states. And if it's appropriate for enactment in their states, seek the approval of their state legislatures. Before that actually happens, we chew on it a little more. We have a committee on style. And I've never been a member of the Committee on Style, and actually I don't aspire to. Those are the people who pay attention to make sure that every period is where it should be, every semicolon that ought to be a semicolon is one, every T is crossed, every I is dotted. And they will work through the act and really make sure it conforms to our normal style rules. And then we will go to the American Bar Association, typically. We don't have to, but we usually go to the American Bar Association at the winter meeting after a summer adoption of an act and seek the American Bar Association's approval for our act. Now, one thing I didn't mention, but should have mentioned as I went through the drafting process, is another point that was mentioned in the remarks that I heard, and that is we invite a broad range of stakeholders to participate in the process. We have been calling them observers. We're going to start calling them participants because they really are participants. They come to drafting committee meetings. They have the opportunity to say what they want to say. They make their views clear typically, and we try to take those views into account because we are a consensus-oriented organization, and if we can bring together something that meets the needs of all of the stakeholders in the process, we want to do that. One of the problems that we have, and it's one that I'm very aware of, is that, of course, that invites stakeholders who have the money to show up, and not everybody does. So industry groups are very likely to be there. Consumer groups are a little harder for us to bring into the fold because they typically don't have the resources or don't have as many resources to participate in the process. But we are working with consumer groups to try and encourage them, and we do typically get good participation from folks other than industry people. So what does that all come up with? It comes out with the really long list of acts that we have adopted, and they're listed on the website. You can see there's 9 pages of current uniform acts that exist, and they range from an extraordinarily across an extraordinarily broad front in terms of state law. They go from the Uniform Athlete Agents Act, an act that might be of some interest here in Indiana, given the success of traditional success of your athletic programs, to my favorite, the Collateral Consequences Act, which as I say, I drafted, which really relates to the civil implications of criminal convictions, and which has led to research that's revealed, just by the way, that there are 45,000 American statutes and regulations that apply to people based upon conviction of a crime and limit their rights and their ability to participate fully in society, to the Uniform Fiduciary Access to Digital Assets Act, which is a statute that we just recently did, which relates to the subject of who can get access to your social media page, among other electronic digital assets, after your death, or should you be so unfortunate as to have a guardian. And we've just gone through that process, and we're now seeking enactment of the Fiduciary Digital Assets Act across the states. We're doing a project right now on social media privacy, which is aimed very much at schools and employers, and to what extent they have the right to demand access to your non-public digital assets, the pages of your account that you don't show to the entire world. That's an ongoing project. We're doing a project now in the criminal justice reform area related to the accuracy of criminal records, which is a huge American problem because people, as I say, the law permits people to be discriminated against based upon the fact that they have a record of conviction, even perhaps based upon the fact that they have a record of arrest. And people are, in fact, subject to penalties and discrimination because of their history. And if that's going to happen, it's certainly important that they actually be the person who's been convicted of the crime in question or arrested for the crime in question, and sometimes they aren't. So that's an ongoing project that we're working on now. What does this all amount to? I think it amounts to a great deal. From my own perspective, I don't think that state law would really be a living and vital force in America today if it weren't for the work of my predecessors and my colleagues with the Uniform Law Commission. States typically just don't have the resources to do the thinking and the research and the analytical work that's necessary to draft really good statutes in this area. I had to face I'm in private practice, I'm in a small firm, I'm mostly a litigator, but I kind of do everything. This week I answered a question about whether or not a trustee could make certain changes in a trust. And if I'd been answering that question in 2008 in my state, I come from a small state, we only have one court of record really that writes decisions that are published on a regular basis. I would have been dealing with 6 or 7 statutory provisions and maybe 20 cases or 30 cases. And I would have ended up saying to my client, well, I don't really know. There's really no answer. The majority rule in most states is this, the minority rule is that. I think the court will follow the majority rule. Here's what I think you can do. It would have been a guess. In my state since 2009, we have the Uniform Trust Code. And the Trust Code really handles from soup to nuts the questions that are raised by the existence of a trust. And I was able to read the trust document, read the power, look at the trust statute, and come back and say, well, here's the answer to your question, with pretty solid reason to believe that I'm right. Is it free from doubt? Nothing in the law is ever free from doubt, I guess, but it makes a tremendous amount of difference. And that has a huge impact on the way we all live, on knowing what our rights are, knowing what we can afford to do in commerce. We're here in the Eck Hall School of Law. As it happens, I met Frank Eck once. He donated the money for this school, this building, and the tennis center, and I guess it's the alumni building. Frank made his money doing what I think of as Article 2, the sale of goods. He created and sold drain pipe, plastic pipe that's used to drain soil, particularly in agricultural buildings, agricultural processes and around buildings. And he made a huge amount of money, and he was very generous with this university as a result of it. I don't think he could have been as successful as he was if the law of the sale of goods was not clear and well established, and that would not have happened but for the efforts of people back in the 1950s to develop the Uniform Commercial Code, which is sort of regarded as the signature work of the Uniform Law Commission, and is one of a number of acts that's been adopted in all 50 states. It took us a long time to get to Louisiana, but we did. And it's been a very important influence on commercial law in this country. Federal law advances by leaps and bounds and tends to fill the void if there's not something there. And that's okay in some circumstances when there's a need for the law from one state to another to be the same. It's appropriate for the federal government to come in and say, here's how it's going to be. But those who thought that there was a point around federalism, that the states ought to have some ability to make their own decisions, I think had a point. And the laboratory of states, the idea of states doing things a little different, learning from one another, and moving in the direction of wisdom based on experience, I think is really very meaningful. And the Uniform Law Commission helps to keep that process alive because we're able to say to the federal government, you don't need to get involved in this process. Let the states handle it. Of course, our need to do that in the last 6 or 7 years has been much reduced because Congress can't seem to agree on anything and pass anything anyway, which is another problem. But it has been a really very important element of the effect of the conference's work. And if you think about where we're most active, there are, I think, of 4 things where state law is really dominated by the product of the Uniform Law Commission. One is business entity law, apart from the law of corporations. So the law of limited liability corporations, the law of partnership, all of that comes, unincorporated associations, all that typically comes from the work of the Uniform Law Commission. Long ago, we made an arrangement with the ABA, and they handle the corporation side. The second area, which I think obviously is very important, is the commercial law area, not just the Uniform Commercial Code, but all of the statutes that are related to that. And that's typically been a product of the Uniform Law Commission working in conjunction with the American Law Institute. It's a partnership arrangement between us and them. And then there's the law of estates and trusts. I mentioned the trust code. The real signature work of the conference in this area was the Probate Code, which was done in the 60s, I think, which was probably not adopted verbatim or even substantially, but influenced the law in almost every state and moved the law in the direction of processing, handling estate problems in a way that was appropriate to the estate problem. So the average estate doesn't need much judicial attention. And the Probate Code allowed that to happen, allowed that to be simplified. Some estates have big problems. They need the process of dispute resolution, and the Probate Code helps to make that happen. There's a fourth area that's really been big, and I can't think what it is. I just have had a mental glitch. But I probably said enough anyway. What's that? Family law, of course. That's exactly right. Thank you, Anita. Family law has had the Commission's been very active in the family law field, and really, I think the work of the conference dominates the family law field. For a state like mine, and for many states, one of the things that's really wonderful about the Uniform Law Commission work, and I remember this from my days as an appellate law clerk. I started out clerking for a judge in our state Supreme Court. One of the first things that I saw was a situation in which we were looking at a Uniform Act that had been adopted in our state. We didn't know quite what it meant. We went back and we read the comments written by the reporter that gave the background for the particular statutory provisions. And that really helped us to understand the law and decide the case, I think, in the right way. So that's one of the other aspects of the way the conference does its work that I think is really important. So I'm really high on this process. If I wasn't, I wouldn't have spent 21 years spending much of my free time doing it. If you're interested in legislation, you ought to be too. And I hope this helps to put that all in context. And with that, let's give a broader range of people a chance to talk about this. Which end? The acoustics seem pretty good here. Can you all hear me without the microphone? Oh, we're recording. Okay.
Yeah. Whatever you guys.
Hold it.
What's this? Are you gonna?
Okay, I guess I'm starting because I'm the only one you haven't heard from yet. So, I was involved in this process as an observer. I guess later, you're going to be called a participant. So I spent 3 years working with the Commission on the Home Foreclosure Procedures Act, which was a daunting process. The Commission has tried 4 times to write a Uniform Foreclosure Act. The first 3 didn't go anywhere, and unfortunately I'm concerned that this one won't go either. But let me talk about the pros and cons. It's been approved, but where this process works very well, as you've heard all morning, is when there are gaps or there's some need maybe for uniformity that doesn't exist. And you would think that home foreclosure law in our modern age is one of those areas because the Uniform Code, Article 3, covers most home foreclosures. And so it was thought that a uniform act, making everybody follow this in a uniform way, would make sense. We've got all national banks who are involved in this process. And we have a law that is actually supposed to be the same in every state. And what was happening, though, is the states were interpreting it in very varied ways. And as we discovered when we got into this process, they want to continue to not follow the UCCs in the ways they don't follow the UCCs. But from the standpoint of an observer, I wanted to sort of talk about my thoughts of what are sort of the pros and cons of this process. First of all, this isn't the only agency, organization, whatever, that's out there trying to create uniform laws. There's a group called ALEC that is very active in creating uniform laws, but it's a closed group. It's an industry group, paid members, the like. They create a lot of uniform laws and go into states. And in my sense, it's, and I will be openly derisive about the process, it's kind of like buying democracy, you know. It's a very closed process. And they're very influential in a lot of business laws, a lot of very anti-consumer laws, and as you've heard, I am a consumer advocate. This process, on the other hand, is a very open process where consumer groups can be involved and be part of the process. As was already pointed out, one of the difficulties is we don't have the money to come to all of the meetings. Now, I had a very generous dean who sent me to 3 years' worth of meetings all over the country. Not everybody has that advantage, and so I was able to pitch it for the consumer groups that didn't have the money. But that is one of the problems that you do have. Industry can stick it out, whereas smaller participants can't. The positives are that everybody does get listened to, and everybody does get to participate in their in what's happening, and we do provide the expertise. I have to say my first surprise as a participant in this group was frankly how little many of the commissioners actually knew about what was going on. I was pleasantly surprised that they actually do listen and react to that. As part of our process, we also spun off a few committees. I was on the mediation committee where we actually looked more intensely at certain issues that were going on. So I would think that, you know, again, I was going to say the challenges are that you have a lot of divergent voices and you want to hear everybody, and some of the agencies, some of the more well-financed groups can stick it out longer than you can. And that was a bit frustrating. And I don't want to say too much more about it. I think if people want to ask questions, I'm going to let everybody else just give a little bit of talk because of the time issue so that you've got some chance to answer, you know, to ask some questions. But in just letting you know that my perspective was that as the observer, and you really know that you've become a geek when you're actually enjoying sitting in a room for a weekend with no windows and going line by line over statutes on commercial law. It's really quite sad. And you come out of it excited. It's really bad, but whatever.
Well, I don't have a great deal to add to my discussion this morning. I think Rich gave you the broad overview of our organization. Now, I can still see some of you sitting there saying, well, that's great, but why in the world would you do it? And I know Rich and I have had this conversation. When a new commissioner comes on board, you can almost tell within the first 3 hours whether that's someone who you will be like Rich and I that have been there 21 plus years, or whether they will be there that day and we won't see them again. I don't know what it is, but it's a situation where the process is one that excites us for some reason. And as I said, and I meant this very, very sincerely, you have a lot of lawyers there who are like myself. You know, we have general practice. We don't have a great deal of expertise in anything. But we are made to feel, and the process allows us not only to learn, but to contribute. And I think it's that ability to contribute that excites us and causes us to keep coming back. I was remiss this morning, and I don't know whether there were enough of these little brochure things on human trafficking for you all to all have one. We do have a website that is specifically set up. This was something that the executive committee was able to coordinate with LexisNexis to establish. It's www.letsendhumantrafficking.org. The reason I point that out to you, and I can give it to you again later on, is that you can go there and find out what's happened in each state, what we've been doing, copy of the act, and I believe that we can also be accessed there where you can go all the way back and look at our initial drafts and comments and that type of thing. So that's a fairly comprehensive vehicle that you might well be able to utilize. The other thing I would say, and this ties back into the human trafficking, but it's I think Rich and Anita would both agree that it applies to all of our uniform acts and our work. We do what we think is a great process. It works, but it still then comes down to an individual legislator, an individual commissioner, someone with the passion to push the idea. I found this especially true in the human trafficking field. And one of the things, as President Cassidy mentioned, is that part of the responsibility of a uniform law commissioner is that once an act is adopted, we have a responsibility to go back and promote that act in our states. So we talk about the geek factor, which I've never been considered a geek, but I guess maybe I am when it comes to this. But then there's the action factor. And one of the other things that Rich mentioned about the type of folks that we also have legislative members. And we have some of the most conservative legislative members, and we have some of the most liberal. And as Rich was talking about his colleague in Vermont, that's sort of the old liberal bear. We have one or two commissioners who I shan't mention. I think one of them may even be from Indiana. That's probably about as conservative as you. And they work together to make the acts better, and so that's why you see us sort of smile when we talk about this. It's a process unlike anything else, and it is substantially different than ALEC and some of the others. So that's my addition for whatever it's worth.
Let me just pick up on the point you make about the old liberal bear and the old conservative. I'll even name names, and I'll name them in the service of this cause. I hope one of the things we're doing by talking with you is recruiting some people who'll be interested in our process in the future. And I would say to you that if you're going to be involved in the legal profession, that there's lots of opportunity to be involved in the conference, not just as a commissioner, perhaps as an employee of the conference, perhaps as an ABA representative to the conference, perhaps as an industry representative to the conference, perhaps just as a lawyer who wants to follow what's happening in your subject area on the web and look at the drafts and write some emails or send some letters to the committee people and make your views known. That process of being involved in this can have a really tremendous beneficial impact on your career. The liberal bear from Vermont is my good friend and mentor, Peter Langrock, who joined with the conservative, I don't know what we'll call him, from Indiana, Jim Bopp, and together they challenged the campaign finance legislation in our state and ended up going to the U.S. Supreme Court and winning a victory for the First Amendment from their perspective. I might have taken a different view of it myself. And in the end, the two commissioners flipped a coin to decide who was going to argue the case. And I don't say that comes just from Uniform Law Commission work, but I do say that what you have to offer in your professional career to the people who are your clients or your employers is what you know. And participating in this process can help you develop what you know in a way that's really very, very important. It can help you build a specialty. It can help you to expand that specialty. And so it does have something very real to offer for people who want to have something real and of value to give to their clients, their employers, whoever it is that they're making their living with.
Yeah. I'll just 10 seconds, which is just that I was hooked because of the fact that it is a place that is nonpartisan. You can work alongside, so you may know who's the liberal bear and the conservative bear, but I've worked alongside people for a decade, and many I don't know what their political affiliation is. In today's world, that's pretty extraordinary to have people work side by side, really trying to work for the common good. And for all of you, I mean, I think the larger issue is you're going to have to figure out how to spend your time when you've left the law school, both practicing and then in your public service and civic duties. And so the ULC is worthwhile because it is a place where people work together, they collaborate, they compromise, and it hasn't become a partisan organization. It's looking for the best ideas. And so I hope that whatever you choose to do in your own time as an attorney, look for those types of organizations because that's what's going to advance our country.
Well, this has turned out to be the easiest job of moderating I have ever done. I think I'm the moderator, and the last one to have the microphone. What we're going to do, just to let everyone know, this was originally going to have ended at 11:15. I think we're going to extend it a little bit because these are important and interesting issues. And I think that the panelists so far have really already identified the kinds of questions that I would have asked, but we've already talked about them. So the best thing would be, I think, at this point, to open it up and to see if you have questions about the general process. I have a couple I'd love to ask, but I think it's more important to hear your questions to the commissioners and to Professor Fox.
What are the advantages of having the DI done in state laws as opposed to one federal law? Is it that the federal government doesn't have resources to either investigate or prosecute these crimes, or that you can't get something passed in California?
Who wants to take that one up?
Yeah, well, I'll start with it. So one of the things that may not have come through today, and it's based on it. If you remember, again, for all of you in your 1L classes, what law did you study when you studied torts or contracts or property, mainly? State law, right? So when you think about original, what we call either common law or private law, right? Law that settles disputes between two parties. Family law is another example, right? About private rights. That's the province of the states. So when President Cassidy spoke to you guys about where have we been successful, it's in areas that really are about state law, right? So you can't, so uniformity though is about, if you think about family law, right? You know, families move, they get divorced, you think about veterans and soldiers, right? You want to have people have those same kinds of rights in important areas in the 50 states, right? So there's a question of, there are certain areas of the law that are traditionally the province of the states, right? And just remember 1L, your 1L year, as proof of that. And then remember and think, are there areas where it's important to think about people having those same rights, right? So like child custody, right? If parents divorce or separate, would you want similar rights? Or if there's a will, right? Would you want similar rights of inheritance in different places? The answer is not always yes, but when it is yes, then there's a role for the ULC.
Let me just add to that and say that when I joked a little bit about the idea of verbatim state law from state to state, one of the real substance behind that joke is it's very rare that a uniform law is adopted in a way that is even close to verbatim. And there is room for local variation, and there is an appropriate role for local variation to take into account the particular legal culture or social culture of the state in which the law is going to be adopted and then enforced. And so the federal government really can't do that. And I think it would be a shame if all of these traditional areas of state law, family law is a great example. They're really big needs that are national in scope, and where it's appropriate for the federal government to have some involvement in family law. But primarily, that's local stuff. And we ought to allow the states to have their own say about it. But we ought to allow them to do it working from a framework that has been thought through, that does take into account the history of the law in the area and the experience of other states. And that's really the fort of the Uniform Law Commission.
And I just want to, not speaking particularly on the trafficking issue, but we've already heard that, certain areas the states like to be in charge of. That's their traditional areas that they've been involved in. But I really do think one of the important issues is this idea of really at the federal level, they don't know how individual prosecutors, for instance, offices work, or individual, public defenders' offices work. In my area, the home foreclosure law, some states have judicial, some places have non-judicial foreclosure. And so by the beauty of the Uniform Act is that it can give sort of a framework for what needs to be uniform, because we have banks working across state lines and agencies working across state lines and trafficking across state lines. But then it can, as we've heard the term bracketed a lot, they bracket out little things where, fill in your state details here. And just from a sort of psychological standpoint, it doesn't feel like it's being imposed from above. So there's often more buy-in to do it if it feels like we did it here in our state, as opposed to the federal government told us we had to do it. And in some states, that's more important than others. In some states, there's a lot of pushback on this idea the federal government told us to do it. So you get more buy-in from the state, and then you're more likely to get, because not every law that's on the books gets followed. And not every crime gets prosecuted. So it helps, I think, to have that state buy-in on something that then it actually is used and works. Did you want to add? Mic moderator?
No, I'll speak.
This is a very specific question. I don't know if you would know off the top of your head, but one place where I know that there's a lot of disparity between the states is in testimonial privileges. Do you know if there is any proposals right now for a uniform testimonial privilege?
I apologize. I do have to repeat the questions apparently so that it is caught on tape. And I forgot that for the first one. So the question is there any work being done on testimonial privileges and whether there'll be uniform provisions with regard to testimonial privileges? Is that correct? Yeah.
There is a uniform evidence statute, evidence act, and it does approach testimonial privilege from a general perspective and provide for uniform rules if the state should choose to adopt it. It has not been a tremendously successful product of the conference, and it's not something that is on the horizon to be refurbished anytime soon. But there are a set of uniform rules around that.
Well, that actually raises a question for me as well. Not all the uniform acts have been successful. I mean, some of them have been widely adopted, some have not been adopted. Article 2 famously had issues 10 or so years ago. So I mean, what's your sense of how does an act become successful? I mean, what are the, I don't know if you can tell ahead of time whether an act becomes successful, or what are the difficulties that are faced in the implementation and the passage of acts?
Anita, I think you should take that to start.
Well, I'm a commercial lawyer, right? So I think of, again, the Uniform Commercial Code as one where, again, where our greatest success has been in areas that are traditionally state law. Private law matters in terms of family law, commercial law, et cetera. But Professor Tadmash, you mentioned the Article 2, and I think part of that, too, is that as we look at new industries and new parties coming to the table, our process is becoming one that's different, right? Before there were less, we have more participants now. We have greater. So it's sometimes hard to predict, I think, when you start, that everyone thinks that there'll be a need for uniformity. Mortgage foreclosure, I think, is a perfect example. So I'll hand it over to you, Professor Fox. So I don't think I've seen the recipe yet for what will or won't make for, and I've been surprised.
I think in some sense we were surprised that it was actually industry that wanted a Uniform Act. And I think the reasons they wanted a Uniform Act were very good, which I mentioned earlier because of the UCCs. But you have the same formula that makes a Uniform Act successful sometimes makes it unsuccessful, right? Property law is so uniquely a state issue that the states are very, very protective of their property law, and they don't want you to change anything. And so trying to make even logical uniformity sometimes gets this pushback of, well, we can't do that in our state. And you end up with so many brackets that it's almost useless to do. And also, you do have the industry, or I should say the players out there. In the particular climate where we were doing the Mortgage Foreclosure Act, for instance, let's just say that the consumer groups and the banks were not very friendly. The process is very friendly, right? I mean, everybody's very cordial and working in the process, but an example is anytime we would get something in the act that we thought would help consumers, the Mortgage Bankers Association would stand up and say, well, go ahead and put it in because we'll fight you at the state. Well, that doesn't give us any incentive to try to get this enacted if you're going to strip out all the good parts. So I think that it's a fine balance between, is this something uniquely a state issue, and is there enough uniformity already in the states that a uniform act can fit in, or are we so wedded to our individual local practices that we don't want to let those go no matter what, even if it is in some, and in this case, I thought, would make more sense because there already is so much federal law out there to force uniformity that it would have made sense to smooth it out, but people are so proprietary, really, about their state law that they don't want to give that up.
You know, there's, in another field, you'll know it when you see it, and we keep thinking we're going to know it when we see it. Rich, just a couple of years ago, was chair of Scoping Program, and Anita is just leaving the Scoping Program, and I had the honor to serve on it last year, and thanks to the President Cassidy, we're going to have the opportunity to be on Scoping Program again this next year. We go into looking at every proposal with the belief that we're going to be able to determine, is it good, is it something that needs to be done, is it something that will, if we're successful, will be embraced. And I don't think we have any better answer now of how to ascertain that in advance than we did. We have committees of our committees looking at trying to determine how we ought to do it, and we still don't have the answer. As you point out, and part of our whole process, this study process, that's sort of the safety valve. And before the executive committee makes final decisions on, well, yes, let's proceed, because as President Cassidy mentioned, it's not an inexpensive or a simple process. We talk to folks, we talk to the advocates, we talk to those that are going to be advocating against us, to try to determine, is this something that once we put the work in, we can have some success. And I must admit that I don't think we have, we keep trying to improve the process. I know President Cassidy has had some ideas and additional things that he's suggesting we potentially do. But the answer is, at this point, we don't know until we've done it.
Probably time for one last question. So.
I would say ask law students next year. What's the best way, since we aren't experts in our field, we haven't had a field yet, what's the best way for us to become involved in the next few years, as students and then as lawyers?
Involved in. So the question is, as either law students or young lawyers, what's the best way to become involved in the work of the Uniform Law Commission?
Well, I would say this. I think that if you can, you should pick out a field that you're interested in, that we're doing work in, and begin to follow it. And that's just the basic, simple start. There may be lots of other opportunities. Of course, if your job may affect what you might want to do in that regard. We do have a Uniform Law Commission's Fellows program, so we do hire a few students few former students to come in and work for a time doing research and assisting us in our process. And we hope we get some great applications from Notre Dame after this effort. And then I would say you might think about getting involved in an ABA section that relates to that area that you're interested in or that you need to be interested in for your job. And you might step into the uniform law process through that avenue if another avenue doesn't open up for you.
And just as part of that, so if you're interested in family law, for example, if you, for your employer, start following a ULC Act and process, you don't have to travel to follow, but you can also submit comments and engage. But you can also, for your clients or for your boss, if you know what's going on, you can educate them, so you can say, look, this is going on. Maybe I should be an observer or participant and actually go to the drafting committee meeting. So actually just starting to follow and making this part of your larger, education means that you can actually develop an expertise and find a seat at the table because of your being entrepreneurial.
One last really quick comment. I think one of the nicest things, the best things about this process is it really is open. So you don't have to be an expert, to comment, to write letters and comments, and all of those get aired in the meetings, or at least circulated to everybody. But you can show up at a meeting as an observer, and maybe you're not an expert in this area, but you know that in your particular state, what they're saying might not work in this particular way, and that's always valuable. And frankly, even just being an observer and actually just observing and listening to the dialogue and listening to things, you can really learn a lot. So I think there are multiple ways that you can be involved, from just following on the internet to just showing up at a meeting if one happens to be in your town as an observer. It's very easy to go online and register and you're in, and it's really quite interesting process.